February 26th. Then we're going to continue with some additional testimony on H22222 as introduced and the amendment. And I will welcome Kim McManus to the chair, please. And we will also hear from Charlie again this afternoon, responding to anything we heard this morning. But we'll start with Kim. Thank you for being here.
Thank you for having me. For the record, my name is Kim McManus with the Department of State's Attorneys and Sheriffs. Before you today to comment on H22, Section 1 and the amendment in Section 2, which was presented, I believe, yesterday. So just as a starting point, just to level set, the state's attorneys and sheriffs, while we will inform individuals of the ability to get an RFA, we are not involved in the RFA process, right? In that civil part. I believe when I was a DV prosecutor, maybe I went over to one or two for some really odd reasons of why I was there. It was not normal. Our victim advocates are often the ones most aware of whether if within our criminal case, a person has sought a temporary RFA and is continuing on to a final RFA, our victim advocate will be aware of that and will communicate that. And we absolutely want to know that information so that we're aware if there's a violation of that prevention order. So that's information that we definitely gather. But again, in the actual process of what the victim is asking, the plaintiff is asking for and what the court is ordering, our department is not directly involved in any way of that. Judge Zone, I believe, earlier today pointed out all the issues from the court's perspective of this being potentially a condition. Big picture, as a former DV prosecutor, I loved handing out or asking for any education, therapy, counseling. I thought everybody should be in it. So I greatly appreciate what the network and the Council on Domestic Violence is wishing to do of bringing this program to individuals without needing to go through the criminal justice route. With that said, we just wanted to point out from our perspective, just a few issues that we see. The first one, and I believe this was mentioned yesterday and a little bit today, is just that awareness of the variety of the DVAP programs around the state. So the flexibility is built into the standards that they, I believe, want the programs to be able to interact and reach individuals in different ways and therefore are not standardized. So you are going to have different programs in different counties, depending on where the individual was assigned to access their DVAP. So just to have the awareness of that. And as Judge Zone pointed out today, judges will not always be aware of what the program, maybe all the details of the program and how that might fit with the individual. Whereas on the flip side, on the criminal justice side, prosecutors and probation and victim advocates are very aware of their DVAP program and when that's a perfect fit, and sometimes when we'd want to advocate for an alternative programming depending on the individual. I believe Judge Zone touched on this, but I did have a note about the time to complete the programming. And we're looking at this from the lens of if there's a violation that winds up in our office. Yeah. And so I just noted, I know from the probation end of having DVAP issued as a condition, there are sometimes issues of starting the program, getting into the program, sometimes, and it very much varies. Sometimes folks get right in and start up. Sometimes there is a month or two delay. Then somebody starts the program, then they maybe miss 2 classes. Depending on the contract, you can miss so many classes before you're removed. Depending on the contract, you can sometimes start the program midstream. Sometimes you have to start from the beginning. So when I was reading this, I was just thinking about if it's a 1-year final order, whether or not if it's somebody can complete that 26-week program in that year, what's going to happen if they're not done? And as mentioned, who does that information get back to? So we know either that there's a request to extend the RFA to give the person more time to complete the programming, or is this now where there's been a violation and we need to file that violation before the RFA expires? Which then brings us to the mechanism for reporting how someone is doing in the program. On the probation side, we regularly would hear from the DVAP provider how folks were doing in class. We had meetings on this. We knew when someone was struggling to engage and probation was able to help that person, encourage them, or we knew when classes were being regularly missed and this person was maybe one class away from being out of the program. Something for this committee to consider is whether, and I don't know whether this is possible with DVAP providers and their contracts, is whether or not they would be reporting out when someone is missing class or being removed from the program. Who are they telling that to? And what the next steps are. Last point we wanted to raise, and this is more just a clarification and something for the committee to think about. Yesterday, I believe there was a discussion around violation of probation versus a violation of a prevention order. And I may have misheard the comment, so I apologize if I did. But I believed I heard something that essentially said, a violation of probation is more serious than a violation of a prevention order. And I heard something to that effect. And I just wanted to point out for the committee that a violation of a probation order for not completing your DVAP, you might have a suspended sentence. And yes, that's a serious consequence if you might have to be incarcerated for any of that time due to a violation of probation. A violation of a prevention order is a serious offense in that it's a predicate offense. You get your first violation of a prevention order. If you have that, and then you have a domestic assault charge, that immediately levels up that domestic assault to a second-degree domestic assault felony charge. And your second violation of a prevention order is also a felony charge. So just something to keep in mind, the consequences for someone not completing this program, they are serious. And if this is brought to a state's attorney that this was ordered by the court and someone is not complying, and again, I know the committee talked about what does completion mean, what does complying mean, and that would be very important for the state's attorneys to know so that we know when to file this violation. And we do take violations of prevention orders very seriously. So that we would follow up on this, even if that's, we understand this bill is trying to keep folks from not needing the criminal justice side, but if they are violating a court order, we would need to act upon that.
Questions?
I have a few comments on section 2, but that's for section 1.
Okay, questions on section 1? I have a lot of things floating around in my head, but I think
Yeah.
So, all right, so an individual who takes longer than 1 year, I mean, presumably court without a verification process, which it's unlikely we're going to have one, wouldn't know that it hadn't been completed. But possibly the provider could know that and could inform presumably the person who sought the RFA to seek an extension. And that's one possibility.
That would be, I believe Judge Zone pointed out, that's putting a lot on the plaintiff who has sought this order because of an abusive situation. So I think that's having that person be responsible for that reporting. I think that's just a difficult thing. And though, to be fair, often other violations are reported by the plaintiff. So not to say, but they're reported to law enforcement, who then bring it to the state's attorney, who we then, are investigating whether or not there's been a violation. With the RFA, without an extension, that is it ends on the date set on that order, right? It ends. There's no,
But in any of those situations, the plaintiff would have to be the one seeking the extension anyway, right? Nobody else is seeking the extension.
correct. So that would be, right, whether or not, as the court said, they can't on their own,
Well, they won't.
large.
Yeah, right.
risk
They won't
because-
build the facts either.
Right. So whether again, I don't know whether DVAP providers would be comfortable with this either, because they're trying, and of course, the network can speak more to this. They're trying to create, a relationship to connect with this person, but they would be the ones who would know whether or not someone's going to class or not, or has missed class or hasn't done homework assignments, whatever the contract states as what you need to do. They are going to be the one most informed. And when this is a probation issue, that's the person we need to bring in to testify to the lack of compliance.
Ian,
Do you have any and I apologize that I missed this, but I don't think I heard. Do you have any language for who wanted to put something in to protect a defendant or criminal liability in a pending criminal charge if they're in the DVAP program in compliance with an RFA?
Meaning they have a criminal charge at the same time as
Yes,
this
my question
RFA?
was terrible.
No, that's okay.
Basically, what we heard was the state's attorneys are going to be worried about us giving some blanket confidentiality or immunity because maybe there's something that's disclosed that's like that should be charged with crime that's not related, which I can see that. So do you have language where it's carefully tailored so that you could have somebody participate fully in a DVAP program in an RFA while not having an issue with the Fifth Amendment question in a pending criminal charge?
Well, I think so. If they're in DVAP from an RFA order and they have a parallel criminal case for the same behavior, then we already have the facts, so to speak, for our criminal case. What they would say in their DVAP program would be akin to, if we had counseling and therapy, we're not, going in and trying to get that information. Like we appreciate the confidentiality that's needed for folks to access, that sort of therapy or counseling. So I don't think we're as concerned about, if they make a disclosure there. And again, the network could speak to, I think, again, in their contract. I think this is just from my personal experience with our DVAP provider. If somebody was making a threat of future violence, right, there's that confidentiality does not hold if we think the person's in danger, at least when it was through the probation side. I don't think that would change if somebody is in DVAP from an RFA. I think the contracts would be very similar, but again, I haven't seen one. So that one scenario aside, if somebody's in DVAP on an RFA and we do not have a criminal case, again, we're not really in it. We're not involved. So what they're saying in there, if it was said elsewhere or the victim came to us with a disclosure, right, we would use that account. And to your point, we wouldn't be able to use what the person said in therapy, but we would get to the facts a different way.
Yeah, and I don't think it's relevant at all if there's no pending criminal charge. I think it's only because I sort of assumed, and maybe I'm wrong on this, that if you didn't have an RFA with no findings, so you had like an RFA, you had the hearing and you had a final decision, that civil hearing, that anything that was said in that, if there was a pending criminal charge, could be used against them in that criminal proceeding.
Yes, that's true. In the hearing, if the defendant testified and made certain disclosures, that can be used.
And so I basically have been operating like the DBAP is just basically an extension of that. But I think if I'm understanding correctly, then that's more of like therapeutic. And so it's not, there would be privileges that could be asserted or are asserted that you wouldn't be looking to try to.
Yeah, again, I don't think we would be seeking that out as a area. Because, and I think it's important to step back, like, at least from our understanding of this bill, it's not that folks are trying to circumvent or there may be a parallel criminal case, maybe. We understand when victims choose not to make that report, but want the protections of the court. And so we're not looking to force that on a victim to pull it over. Like, essentially, we're not looking for extra work, in that we understand when the victim makes that choice, and we respect it. But so as far as the confidentiality within DBAP, if somebody's making disclosures about their behavior, that's not an issue necessarily for us. Again, if there's criminal behavior and the victim wishes to bring that evidence to us, we will follow up on that.
So if you were prosecuting a case against that same person and they're in DBAP and they're making disclosures about, I'm not like, let's say it's not about exactly the crime, but like they're making disclosures about the relationship and things that have happened, is that that would not be something that a prosecutor would be looking at trying to get?
I cannot speak for everyone, but it wouldn't be where I would go to get information. Again, I think we appreciate the need for these interventions and therapies. And if somebody's going in there thinking anything that they say is going to be used against them, that's, going to immediately impact their ability to engage. So I don't think we'd want to create, essentially exactly, or an intervention that just doesn't work because they're not going to really dig in and discuss.
Yeah.
But again, if they disclose something that's a public safety issue, that there's a victim safety issue, I believe, and again, the network can speak to this, there's mechanisms where the provider would alert the right individual so that we can protect that person, because the victim is very centered. They're very aware of how folks are responding in the classroom and how that may filter out when the person goes home. So at least the provider we worked with was very, very conscious of how things could impact the victim as the person was going through the coursework.
Other questions on this first section? Yeah, go ahead.
Yeah, so with a notification to a victim, are you talking when the person goes out of compliance?
Well, so what I was just speaking to was if an individual is in class and getting aggravated, getting upset, starts saying things about the victim, maybe saying things like, when I get home, I'm going to XYZ. And I don't know how explicit it would be, but we've had moments where the DVAP provider has alerted, and again, we're on the probation side, hey, so-and-so is really elevated. We're going to contact the victim just to have space, make sure they don't go home to them, like just to make sure that, because a lot of big feelings are brought up in these treatments, and I shouldn't call it treatment, but intervention. And so there is contact with the victim when needed, is my understanding.
So say if it got to that point, and maybe you already said it and I missed it because I was thinking about the whole thing, but is there an intervention process for somebody that is in the program that is at that stage? And kind of what was going through my mind is that a few years ago, we put in a process with retention at the 3-year mark with judges, which, you know, if a judge is kind of getting off on the wrong track, they can potentially be brought back. And I'm just wondering if this system has that. I'm gonna guess, well, I'm gonna say I hope so.
Yeah, and again, the network can speak directly
Right.
to the contracts, but in the contract, they are very specific about the behavior expectations. And again, how many classes you can miss or need to attend and your homework assignments, but that behavior expectation, from my experience, I saw individuals that were removed from the program because of their behavior.
Yep.
And then, but on the probation side, that then is a probation violation, right? They're not able to complete the program because they got kicked out of the program. And then we would have consequences there.
In my mind, before you get to that point, some kind of intervention. And I don't think the intervention would be from the people teaching the program because they're already not getting the respect that they should get at that point. And I don't know who the intervention would potentially be through, if it would be you folks or whoever to, you know, to bring somebody in and say, hey, this is what you're heading toward, and hear it from, you know, say the network or whoever is, you know, teaching or implementing the courses, but also to hear it from somebody else.
Well, and it is interesting, and again, this varies with the provider. What I witnessed with our provider is that depending on the behavior, you know, putting sort of big violent behavior aside, but just, you know, reluctance to engage, a bit of non-compliance, the provider often, you know, would have one-on-one conversations, you know, try to figure out what's going on, you know, help with homework. A lot of the individuals need assistance doing some of the homework tasks. So often the providers go above and beyond,
Sure.
come early to class, stay late. That was my experience. Again, statewide, I don't know if that would be happening. So the provider, I think, can provide some of that intervention. But to your point, when this is a probation condition, we have the probation officer is the one who would be doing that. Hey, person, you are one class away from getting kicked out, or you are consistently late. You are going to get kicked out, right? They're doing that conversation of, and here's what's going to happen.
So the provider
Would inform probation, and there's that conversation. Now, with this though, so that's on the probation side. With this, if it's from a RFA, there is no probation officer involved. So to your question, who would be providing that encouragement, that reminder? It would only be the provider, or if there was some mechanism to say, hey, court, they're not following the order.
Yeah.
And, you know, Judge Zoney spoke to that a little bit today of like, who would bring that to give that? And then is there a court hearing to check in on the person? Because there would be no probation officer type to do that.
All right, any other questions on section 1? Moving on.
For section 2, Judge Zoney hit pretty much all my points. So I'll only just note, we agree of his recommendation of the course of conduct, of moving that up and making it the first course of conduct or the second course of conduct. That makes sense to us, and we had some notes on that. And we do appreciate the point here as well, as someone who prosecuted these stalking crimes, just explicitly calling out this type of surveillance. While I believe we already could meet that definition, it's nice to have this explicit call out. So we do appreciate that. And Judge Zoney gave a number of examples, but having the committee just look at and discuss more the installation, concealment on a tracking device on a motor vehicle and making sure that we're not having unintended consequences. I was thinking of one example. I have a very good friends who someone has early Alzheimer's. And so, that person has tracking devices, all over their spouse and in the car. And it's super important. And this would not be right who we're trying to capture under this. And so I didn't know, and I don't have language yet, but I was wondering whether in the offense, if you did want to add something like monitoring or following the operator for the purpose of, and I don't know if that might help or whether you just need more exceptions. I know the exceptions could start to get long. So legislative counsel might be able to help noodle that along if you want to sort of zero in on the purpose of that, what you're trying to prevent. And then and then Judge Zone, and I know Attorney Brierly mentioned just the court may or shall. Changing it to may, we understand. And again, this is out of our lane. We're not involved in these type of orders, but we did note that the court would likely want may instead of shall.
In your practice in this area, is there any type of fact pattern or situation with electronic stalking that we missed in this bill? Or like a fact pattern that we could I'm just hearing that you've prosecuted in this area and you've seen stuff like this. And what I think the goal of the bill, which is great, is to really update this language so that it's really meeting what's happening in reality right now. I'm just curious if we've got it all.
Always difficult, right? Because things evolve in a new scenario. They're like, well, didn't see that coming, right? Shows up. But I think having the broad electronic, digital, right, GPS systems, like that's giving broad enough language. And I think it's important to understand that the course of conduct language, right, monitoring, surveilling, it's on the prosecutor to prove like what's monitoring, surveilling, right?
Yeah.
So whether it's somebody sitting in their car with binoculars or somebody attaching something on someone's phone, we need to make that connection. So again, this, I think, makes it more explicit, but not necessarily like we could still prove surveilling without it, if that makes sense. Like the cases I had, the issue wasn't, can I prove surveilling? Issues were like the defendant saying, oh, we both track each other's vehicles. Like she agreed to this, right? I mean, like, okay, now I need to prove that she never agreed to it, but then finding out like, yes, all the vehicles are tracked. Like, that's, like that is more like that, less defining a surveilling piece.
Any other questions? See any, so we will go to Bianca next.
Thank you. Thank you, Kim.
Good afternoon. Can you hear me?
Yes, thank you for being here.
Hi, thank you so much. So, good afternoon, all. Thank you, Kim. And I'll just introduce myself to start us off, but I am the provider, one of the providers across the state that Kim keeps referencing. So my name is Bianca Zanella, and I'm the director of a certified domestic violence accountability program of Rutland County called Rutland DV Programming LLC. And I've been facilitating DVAP groups for about 10 years. And additionally, I have 7 years experience as a legal advocate for survivors of domestic and sexual violence in one of the network's member organizations. Thank you all so much for the time you're investing in learning more about our programs and really how passing H222 would benefit survivor safety and our larger community. Really appreciate it. So I have had the benefit of living in these two worlds that this bill would merge, as every week I'm facilitating groups for men who have caused harm. And for 7 years, as I said, I was in relief from abuse order court every single Friday morning here in Rutland. So I've heard countless reports, read affidavits from victim survivors and police, and I've also had real in-depth, breaking down kind of conversations to discuss life-altering moments with the people who have made violent choices. There's a lot of tears, a lot of "I wish I didn't have to be here's," and it's included on all levels from really both parties, plaintiffs and defendants, as we all try to make safer, healthier choices consistently. And so I'm just going to speak a little bit to how DVAP operates as one of the providers. So each DVAP operates slightly differently in each county across the state as we follow a variety of evidence-based curricula, ranging from really more restorative justice philosophies all the way to more acceptance and commitment therapy models. I facilitate an active or more of an acceptance and commitment therapy model. And we accept referrals from individuals, so self-referrals, their probation officers if they have one after an assault conviction, or also from DCF caseworkers if they're operating within a safety plan. And we have participants from diverse backgrounds. But really what brings everyone together peer-to-peer is this shared sense of accountability and willingness to change one's way of thinking. We all agree to these collective group guidelines at the beginning of the program. And we all agree that our current way of doing things hasn't really been working out as we would deem ideal. And so we have a real clear starting point when folks enter into our program. And a theme that we hear over and over again from group participants is that they just really appreciate and are so grateful for the support and camaraderie that we create this safe space over 6 months in. Although every program's time requirements are a little bit different across the state, folks are they're not alone. And sometimes for the first time ever, they're not alone and they're able to talk about these things that are really vulnerable and hard to discuss. And actually, DVAP participants are pretty stunned that there are kind people to help without judging them for the abusive actions. So really, from my perspective, DVAP is useful and life-changing because it's a space where everyone is open and honest and where no one needs to tackle these difficult issues alone. And most people, as I said, are surprised because they expect to be judged, right? There are judges in our criminal justice system, but this is not that, right? So DVAPs have policies outlining our confidentiality policies, which include these typical exceptions for mandated reporting and survivor safety if there's any immediate risk, as Kim was mentioning. So otherwise, participants are free, and as Kim mentioned as well, right, need to feel free in sharing. Otherwise, the DVAP process is not going to work. But we do provide a space for being vulnerable that people really don't normally have access to in their day-to-day lives. And so, again, my perspective as a DVAP provider, creating another opportunity to access the services that they need through the RFA process would be a really helpful avenue for folks to learn and take advantage of this free resource statewide. So just to focus in on Rutland DV programming as an example, we complete a participant after they've attended 27 classes with active participation with their peers, completed all of their weekly practice work, and also demonstrated taking accountability for those harmful behaviors that get them into group. And participants typically report a range of behavior, from yelling to their partner and kids excessively, and they want to manage their anger as one of their intentions going in, to more coercive behaviors, like they just have a really difficult time supporting their partner's independence, working through codependence, or to physical behaviors such as destroying their partner's plans after a night of drinking. So not all abusive behavior shared in DVAP groups rise to the level of criminality, and I want to make that clear. And especially just there's an overlap. Many people come to class also needing sobriety support, and if they're working with probation and parole, they might be on some kind of drug or substance use monitoring. So sometimes that treatment overlaps or is a first step before they're entering into a DVAP. But really the tools and skills that we discuss during our 6 months together and practice support healthy relationships to themselves and also to others. So it can really support people on multiple fronts, not just in isolation with violence. And to further define active participation, at least with my program, we've got backgrounds in education and really a deep understanding of different learning models. And so my co-facilitator and I, we're role modeling effective and healthy relationships as part of our group facilitation around how we are holding space. So we never force anyone to participate. We never abuse our power as facilitators. We hold space and at the same time, really encourage being a bit uncomfortable, only to the range of growth, right? As we know, discomfort comes along with real change. I'm sure you all have been there with I'm a little bit uncomfortable, but this is good. And then as another example, we accept I don't know as an answer, right? And so we work one-on-one with people who may need different accommodations. We move at their pace. And on the whole, group participants say that at the beginning at first, right, they might feel that it's a bit scary. Of course, right? Because it's an unknown. They're not sure, who's going to be in the room with them. They're not sure what this process is like. But by week like 3, essentially, they're usually pretty comfortable and surprised at how safe the DVAP space is. I'm going to just pivot to my other expertise here, which is RFA, or Relief from Abuse Court. And so having been in RFA court weekly up until just this past January, I've actually had this exact thought many times, which is how come the judges cannot or do not just refer defendants in this process to DV accountability programs? I'm like, oh, this is such a good opportunity. And so it is really time, right, to make this opportunity a reality for survivors. And I'm so glad to see H222 before us today. So I'm going to just speak a little bit about my sitting with plaintiffs during relief from abuse order process. So to sit terrifying details of their private lives in an open courtroom setting needs. And one need that I got to really understand well was how much plaintiffs didn't have to go through the RFA process. And really often getting a protection order is like the one step they avoided doing until it felt like that was their only choice. Begging with their partners to go to therapy, to stop abusing them, trying to be perfect so they won't get punished, pretending that everything's okay, and trying their best to avoid conflict and going along with everything that their partner wants are all strategies that a survivor implements to keep themselves safe before they finally resort to potentially trying to advocate for an RFA for themselves and file one. So they're desperate for their partners to get the help that they need so that they can either be a family again or start over or separate and be safe. And plaintiffs are really looking for this safe intervention for their lives to change because they can't go on living the way that it has been. And again, often that RFA process is kind of the final step. And so just from that perspective of survivors who just want an RFA, which is to say that they want to be treated with respect, to feel safe again, to accept authentic mutual love, but they don't want to go through a divorce or parentage action. They're really just looking for that reunification. This is a great way to address accountability and for the children of the relationship as well, to help that healthy relationship model really be fostered. A lot of plaintiffs and survivors will get an RFA and just use like that top box around no abuse or harassment as a condition, but they're still living together. And so if they can be able to access this service, this amendment really could address that generational cycle of abuse, especially for the kids too. I want to just end my comments today with hearing a little bit about some gratitude from the DV Accountability Program participants that I've had. And so the participants from our DVAP thank my co-facilitator and I for changing their lives on a regular basis, citing as some of the most helpful takeaways being the ability to be comfortable, being open with their affection, their emotions, to communicate about them, and developing self-regulation, right, in stressful or distressing situations so that they know how to respond. And participants are learning just to name like a drop in the bucket. They're learning what their triggers are, how their body responds to certain emotional states, processing their own maybe childhood trauma, identifying and changing unhelpful belief systems, practicing how to respond and communicate differently and more effectively, problem solving, and just like so much more. But just to give you a little peek-see into it, any of you are welcome to come to a DVAP to check it out if you want. But for example, I just like to share this this quote from one of our former participants who reached out after a year completing the program just to offer his gratitude. And he said, so it's been around a year since I completed your course. I truly hope all is well, healthy, and happy. Thanks to your guidance and a lot of continued practice, my life is amazing. As you know, I struggled for years with severe trust issues. I tried many therapists and psychiatrists to no avail. Thanks to you two, I am finally free of those chains that held my personal and family life down. I'm contacting you to say thank you with all of my heart, and that was in caps. Thank you with all of my heart. Okay, thank you again for my life back. And when I share that with you all today, I really want to emphasize, right, that this can really help folks get their life back, right? And so without the explicit authorization of the court to order defendants from RFA proceedings to complete a DVAP, many individuals who could benefit from this type of program to really get their lives back go unreferred. And they're lost in the system, the judicial system, and they can continue to make the same mistakes, right? Which harm the intimate partners, harm their coworkers or other relationships, family members, and our community, and many victim survivors just continue to suffer. And so in closing, I support H222 because I have seen the growth of so many individuals who go through the DVAP process. I even say to my participants in group that I love and I really appreciate being able to be a facilitator because it keeps me accountable to my own relationships and keeps me on it. And I strongly believe that these groups would benefit really from abuse defendants as well. And therefore plaintiffs, right, who are for the most part at their breaking point after suffering alone and in silence for really far too long, as the RFA process is not preventative, right? And so as we work in this system, let's continue to move toward more prevention in this reactionary system of change. And so by supporting H222 and supporting judges, right, to include this potential condition, especially in 1 year final RFA proceedings or final RFA protection orders, I believe there will be a significant increase in healthier relationships and net positive for all of our communities across the state of Vermont. So if you have any questions, I'm happy to answer them.
Thank you. Very helpful. Tom.
Hi there. I guess my question would be, I get, is DVAP is the proper acronym? Okay. How many different DVAP programs are there, and what are some examples maybe of the itinerary or timeline requirements? Are there in those classes?
Yeah, thank you, Tom, for that question. So there's usually 1 or 2 DVAP providers per county. We serve all of Rutland County, and also we offer virtual programming. So we have referrals from statewide as well. And so when you contemplate this change, participants from an RFA proceeding that could be referred to our program could be referred to a virtual program, but not in the exact same county in which they're living. So with virtual programming, we're able to have a lot more access across the state. Every program in each county is a little bit different. My program, again, runs for 27 weeks and we meet once a week. Other programs run for twice a week. Some meet for an hour and a half, some meet for 2 hours, once or twice a week, and could run 24 weeks, 27 weeks, 30 weeks, something like this. But most of them are pretty in-depth. There is one program, Circles of Peace, that is a little bit different. They're a more restorative justice process. And so their process looks really more intensive as well. And so when you think about referrals to a different kind of program, right, someone might be better suited to one program than another.
Okay. Now, maybe a couple of parts to this. Are there any studies on the effectiveness between the programs? And does it make any sense that if we did something like this in restraining orders, it'd be standardized? Or if not, that we watch over it to find out what's more effective than others?
So all of the programs that are certified with the Vermont Domestic Violence Council are certified to the Vermont Domestic Violence's standards for Domestic Violence Accountability Program for DVAPs. To think about just your question on general, I'm not sure if there would be a pilot program or a pilot period, but certainly all of the programs that the referrals would come to are already biannually certified to state standards. Did that answer your question, Tom?
I guess so, but they're not all the same exactly though, right? I mean, some have different time requirements or.
Yeah, and we use a values-based standard, which Charlie and Heather could speak to a little bit more, if you wanted more questions about what those values-based standards came from. But yeah, they're not requiring strict number of weeks, number of hours that somebody has to complete in order to have completed a program, because we recognize that there are different evidence-based curricula out there to utilize.
Thank you.
Other questions, Angela?
Thank you so much for being here, Bianca. You just mentioned your virtual programming, and I know that the Judge Zone earlier today was wondering if there are any jurisdictional concerns, or barriers if someone is from outside of Vermont. Are you able to provide your programming virtually to people outside of Vermont?
So that is actually a question that we've been discussing in our Domestic Violence Accountability Program coalition meetings. Certainly from my program, we've had people who live on the New York-Vermont border because we are pretty close to the New York side here in Rutland County. And they started in Vermont and then they moved to New York, and we kept them in programming and they've been in programming. And now, I have one person I'm thinking of right now that transitioned out and now has actually just moved back to Vermont, and they've got about 10 weeks left in our group. Our goal, right, is not to, I think, fund other states' access to this type of programming, right, because the state does fund this as a free resource to participants taking it. But I do believe that, if the victim is living in Vermont and there's jurisdiction for an RFA to be ordered, that's something that we would conceive of.
Thank you.
Thank you very much, Bianca, for your testimony. It's really helpful. One of the things that we're talking about is like what happens if you have the RFA for a year and a defendant hasn't completed the RFA yet, and like will we continue the RFA for another year? Another issue I just thought of listening to your testimony is for a 27-week program, what does your enrollment look like? So do you kind of have like one shot at an enrollment when this course starts, and then if I wanted to get into your DVAP program, I have to wait 27 weeks? Yeah, if you could speak a little bit to that.
Absolutely. So our program in Rutland is a continuous open model, and so we don't have closed starts and ends. So we're always rolling people in, which actually is really helpful to our model of peer-to-peer learning. And so folks who are coming in fresh are actually able to be kind of mentored by participants who might be wrapping up their time. And so there's overlap all the time, and we have open enrollment, and so anyone could join in our program. Many providers across the state operate in this way as well. However, there are some that operate closed enrollment, and if they wanted to be referred to, the closed enrollment models, or those providers rather, then they would be put on a wait list, and those run, you'd have to wait. However, wherever they are in the wait list, they'd have to wait to start.
Thank you.
Yeah.
I like the peer-to-peer that you just described. I think that's a great model. Earlier in your testimony, hopefully I'll get this right. You had mentioned working one-on-one with people, and I think you also said something about working at their pace. Okay, that's good. So my memory isn't too bad then. So what goes through my mind with that, I kind of look at those two things as potentially being an intervention maybe for somebody who's might be slipping a little bit. But I'm just wondering if there's any other, and I'll say tactics that you use, or practices, I guess would be a better word, to kind of intervene with somebody that may be going down the wrong path or starting down the wrong path.
Yeah, thank you for that question. So we recognize, right, that folks are coming in from all kinds of backgrounds, right? And people are coming in with many different struggles on their own. And this is one piece of their life that they need to attend to in order to continue to move toward what's important to them, and in order for, their families all of the time to remain in relationship with them. The one-on-one piece and the moving at individuals' pace is really how we approach this balance between individual and collective educational models. And so the way that we operate, right, we operate a weekly group, but we check in with folks on a periodic basis to make sure that they're doing okay. And so when somebody comes in, we do a lot of one-on-one sessions at the beginning to get them prepped and intaked and ready, and checking in with them those first couple of weeks to make sure that they are feeling comfortable and confident in the material, and just with the group dynamics and everything like this, especially if they have from their school days, right, an IEP, an individualized education plan, and so that we can really integrate and accommodate for them. And then when we think about checking in over the course of the program, right, we're together for a long time, right? For a long time, 6 months. And we do a check-in at the beginning of every single group that we do. And in that, we learn a lot about each other. Those check-ins are really helpful because we allow folks to check in about whatever they want, whatever's on their heart in that moment that they're struggling with, or that their thoughts have been really focused, or we call them hooked thoughts in my curriculum. So, what are they hooked on this week? And so, for instance, in last night's group that I ran, we had somebody relapse, and so we checked in about the relapse, right? And then we're able to check in after group, outside of that 1 hour and a half together that we have, to connect them to those other resources, to make sure, if they are with a probation officer, that they are able to get further connections and resources, and feel like they're able to continue to make progress. And if they're a self-referral, if they don't have anyone checking in on them, right, there's no DCF, there's no probation officer or anything like this, then we do that connection with the resources. What's your local AA, or what's your local NA groups, things like this, if they're looking for those along the way. And then the last thing I'll say on this is that we operate at least with a lot of flexibility. Flexibility is one of the values as part of our standard policies and procedures. And so if somebody is really struggling, or say there's a death in their family or something like this happens, or a medical emergency, we do have the discretion to put them on pause so that they're not going to be missing more groups then would help, and would help them be able to complete the program. So our mission as a provider is really to be able to have our participant be successful in completing the program. So we want to limit as many barriers as there can be, so that that success looks like healthy and safe relationships.
Right, and just one more thing. This is a big education for me on the domestic violence accountability program. Maybe we've discussed them before, but I don't recall discussing them in committee before. So anyway, earlier you invited anybody in that wanted a little more information. And what I'm going to do is turn that invitation around to you. I'm from Rutland County. I'm the rep from West Rutland.
Yeah.
And what I would suggest is to get hold of Senator Collmore or Representative Keiser, because every Wednesday morning Rutland County meets, the whole Rutland County delegation meets, and we have people like you in all the time from Rutland County, whether they're civic groups or people such as yourself or the Chamber of Commerce, and they just let us know what they do and what's going on. So I would highly recommend to contact one of those. So thank you.
Tom. Yeah, I'll follow up on the invitation. Thank you.
Any other questions? Seeing none. Thank you so very much for being here. I really appreciate it.
Thank you so much. Take care.
Thank you. All right, we'll go with to Charlie for some follow-up. And also you may have comments from what you heard this morning, but also want to hear a little bit more about the position on Section 3 related to the crime. Well, if you could touch base on those.
Yeah, I'd be happy to. I'm Charlie Glisserman, Policy Director at the Vermont Network Against Domestic and Sexual Violence. I'm again joined by my colleague, Heather Holter, the co-director of the Domestic Violence Council, who can answer any operational questions about DBAPs I cannot. So I wanted to provide just a couple thoughts that have kind of come up on our end watching the discussion today, and hopefully we can offer some clarifying points for the committee. So first, I just wanted to kind of bring the discussion back a bit to the purpose of the bill and where this recommendation came from. So this recommendation was from the Domestic Violence Fatality Review Commission because opportunities to change behavior were missed multiple times in the RFA process, and they had fatal consequences. And so we really see this as an opportunity for people to access tools to change their behaviors before they face criminal consequences for abuse or further action happens that is damaging to survivors and victims. And so this is really a preventative measure at its core. And I think Laura did a really great job of speaking to the purpose of RFAs and case law and how these preventative measures are really in line with the purpose of these orders. So I want to talk a little bit about process from the DV Council side, as well as some ideas we have about compliance and how this would be implemented with the courts. So as you heard, there are no compliance checks for any condition of an order. And Judge Zone, I think, noted some really important questions about how this bill would be operationalized. We would be happy to speak with stakeholders about this process outside of committee time and follow up over break if that would be helpful to the committee. We have a couple options in mind for you all to consider. If you all are interested in a compliance tool related to DVAP participation, we would be totally capable of having a letter from a DVAP provider upon completion or upon participants stopping participating in a DVAP to go to the victim or the court or both. Providers already send these letters to the victims and the source of referrals, whether that's DOC or DCF. And so this is a practice that we would be happy to, mirror in other places. We would also be open to contemplating adding language on whether this specific violation doesn't constitute a criminal violation of an order, and whether it could potentially be a civil contempt of court instead. This is something that we want to think about and discuss more, but just like want to recognize the committee's concerns and think more about how to make this bill work for everyone. And also just wanted to note, Kim raised a really great point on the ability to complete a program before the term of an RFA. I think our anticipation is the vast majority of people would be able to complete their program within the term of an RFA. But the language in the bill could potentially be something more like progress towards completion rather than completion, if we wanted to address that concern. I would be happy to talk a bit about confidentiality and self-incrimination in the process as well. So we really do see accepting responsibility for behavior and self-incrimination to be pretty different things. A significant portion of the behavior discussed in DVAPs, as you heard from Bianca, are not criminal behavior. And Laura noted that maybe 10% of people who are filing RFAs have a parallel criminal process. We also really appreciated the comment from Kim about the respective confidentiality of these programs, because they are, a really important part of healing and treatment for folks. In addition, as far as kind of options for language addressing this concern, if the committee feels it is needed, in Act 12, which was passed in 2023, that permits some domestic and sexual violence cases to be referred to CJCs if certain conditions are met. In that conversation, they added the language to address confidentiality and self-incrimination concerns within the process. And so we have kind of language that I think could be relevant for the committee to see and potentially add to the bill if that was what is desired. Last thing I wanted to note on process is that we really do have the benefit of these programs being overseen and managed by the Domestic Violence Council. And so I think we're in a really good position to support on the kind of process and operational side of making these programs really work as intended. The last thing I wanted to note here is just speaking to kind of thoughts around participating in DVAP as a sentence. So, first I just wanted to note that 3,000 RFAs about are filed each year. Only 1,000 final orders are granted. And so about a third of folks are reaching to this process who started it. And so these are really temporary conditions and response to very serious behaviors and people who have experienced abuse and fear for their safety and the safety of their children. And so, I also wanted to just level set a bit on that there. As Heather noted, and you heard from Bianca as well, there's a lot of flexibility in participating in DVAP. There are programs in different counties. There are virtual programs, and there are different kind of time slots available in those virtual programs. So they can be used to accommodate work schedules or child visitation, and make it really work in their life. And, I was really struck reading testimonials and hearing from Bianca about the impact these programs can have on people, including people who are required to attend and wouldn't have attended otherwise, and the impact over the course of the program that it can have on their lives. And so we think these programs could really benefit defendants. One thought that I was also kind of thinking through is in cases where there is a parallel divorce or criminal process, if you're participating in a DVAP or have completed one, that is a demonstration of working to change behavior. I think that could be a consideration by the court if that is something that the participant is interested in. And so that could potentially be helpful to them in addition to the impacts of their behavior changing directly on their lives. So I have some potential next steps that I would be happy to share with the committee if you all are interested, and would be happy to speak to the kind of GPS portions of the bill. But I feel like I've been talking for a while, so I wanted to stop and see if you all had any questions.
I think the GPS portion of the bill, we're gonna push off a little bit.
Okay,
And we look at it next when we come back. I
okay,
think it's probably a little bit more than we'd be able to deal with at least this week.
okay,
But
completely understood.
questions on what's been shared so far? Yeah, go ahead.
Not a question, but just one little point of clarification. It was Act 11,
Act 11,
not
yes,
12. I think you said 12 and I wanted to make, I was like.
absolutely, you are
These
correct.
people were looking for it. 12 deals with captive insurance.
Yes,
So you will find it there.
this is not about captive insurance. Thank you.
Good. So could you address that a little bit on that criminal charge, the criminal, in section 3, I guess, is what it would be in the amendment.
Yes. So, we've talked a bit internally about it, and also have kind of monitored conversation in committee where there are some concerns about unintended consequences. And I would say that our recommendation is that we would probably recommend removing the language included in that section. We feel like the bar is pretty high to create a new crime. And we are often concerned about the potential for new crimes to be used by abusive partners against the survivors they're intended to protect. And we've received a lot of constructive feedback from our advocates around strengthening civil protections in this area. We have not heard the same about strengthening criminal protections in this area. And so we would be happy if these aren't sufficient in the civil realm to come back in the future and continue this discussion. The last thing I would note there is that the device-related stalking language that is included in the civil course of conduct in this bill would provide civil protections to people who are encountering situations like tracking through a vehicle. And there are also, depending on the circumstances, existing criminal charges that could be brought against someone in those circumstances. So right now we feel like remedies cover what is needed to be covered.
I appreciate that. Questions? Not seeing any. I'm sure we'll have more once we see the next version, which will probably be taking up the Tuesday or Wednesday when we come back from the town meeting break.
Okay.
So just give them time to work on the next draft. So we're going to take 5 minutes break, and then we'll look at